Good morning. I'm Eric Blank, the Commission Chair, and this is the Commissioners' Weekly Meeting for August 27th, 2025. It's 9 a.m. Commissioner Gilman, you ready to approve the consent agenda as presented or any preliminary comments?
Good morning. Nothing to start out, and I would vote to approve the consent agenda. Thanks.
Commissioner Plant.
I would vote to approve the consent agenda as well.
Thanks to both of you. In the matter of temporary rules regulating railroads and crossings, Dr. Fishaber, Mr. Sarah.
Good morning, Commissioners. Pam Fishaber, Deputy Director of Public Safety. The temporary rules that were put into place on August 6th, we received an opinion from the Attorney General's office and had forgotten to include federal road authorities, just including state and local governments. So the question this morning is to reissue the rules. We're now referring to all road authorities that are not local governments for the 50-50 split, and then for the new requirements on the sharing to just the local government road authorities. So I'm ready for recommendation.
We'd welcome your recommendation.
Staff would recommend that the Commission reissue the temporary rules for the crossing surface maintenance.
Commissioner Gilman.
Thanks, Dr. Fishaber. I agree with your recommendation.
I agree as well.
As do I, and that can be an ABC decision issuing the temporary rules. So thank you, Dr. Fishaber. 25M-0016T, Ms. Ray's, Ms. Rowett, extension of time for filing of the Colorado High Cost Support Mechanism. Oh, you're muted.
Thank you. I'm sorry about that. Good morning, Commissioners. Megan Ruette, joined by Gladys Ray from your telecom staff. Commission Rule Number 4, CCR 723-2-2848D requires the CHCSM Administrator to report to the Commission on the actual CHCSM surcharge contributions compared to the estimated projections received for the first 6 months of the calendar year. 10 rural incumbent local exchange carriers and 2 wireless carriers will continue to receive CHCSM support indefinitely, pursuant to House Bill 24-1234. For 2025, projected contributions were $19 million or $4.7 million to be collected per calendar quarter. For this memo, we used half of that annual amount, $9.4 million, as the forecasted amount for the first 6 months of 2025, or $4,700,000 per quarter. Actual collections for the first 6 months of 2025 were $9.35 million. This collected amount was down 0.51% or 0.5% this year compared to the projected collections estimated in 2024. Based on the actual collections received for the CHCSM for the first half of 2025, staff does not recommend any adjustment to the existing 2.6% surcharge for 2026, so that total collections from the surcharge do not exceed $25 million pursuant to Title 40-15-2082A3 in 2025. Staff has prepared a memo addressed to the Commissioners and proposes to include this required communications into the proceeding number 25-0016T that was opened in January for the reporting of revenues by telecommunications providers. And we are happy to answer any questions that the Commissioners may have about this memo.
Commissioner Gilman, I don't think there's a vote or any approval. I think this is informational. Any questions from Ms. Ruette?
I don't have any questions, but thank you very much. Appreciate it.
Thank you.
Same. No questions. Thanks for all your work on this.
All right. Thank you.
I greatly appreciate the information, and we'll see you next time.
Thank you.
Proceeding number 21A-0141E, Mr. Davis, Public Service Company, Colorado, 2021 ERP. It's still hanging around.
It is. Still hanging around. Good morning, Commissioners. I'm Ron Davis of the Commission's advisory staff, and I'm actually filling in for Michael Eden, who's eager to take up more of your time later this morning. on another ERP.
You're welcome for us letting you go first.
I think eager might be stretching it.
Oh, okay. I'll tone it down. So last Friday, trial staff of the commission, along with the Colorado Energy Office and the Colorado Office of the Utility Consumer Advocate, filed a joint motion with Public Service Company of Colorado, requesting that the commission initiate what the joint movements call a near-term procurement. The motion was filed in Public Services concluding 2021 Electric Resource Plan proceeding, where the commission reviewed the company's clean energy plan. In brief, the near-term procurement entails the potential acquisition by Public Service of new generation resources in light of the recent legislation by the United States Congress and recent directives from Colorado Governor Polis. The joint movements argue that time is of the essence because generation project developers and the company need rapid project approvals to qualify for federal tax credits. In essence, the NTP entails the issuance of a request for proposals for new generation on this Friday, August 29th. The solicitation is for the potential procurement of up to 4,000 megawatts of renewable energy and hybrid projects, 200 megawatts of thermal generation, and an additional 300 megawatts of firm dispatchable generation. Public Service will conduct outreach to projects previously bid into the 2021 ERP and Clean Energy Plan solicitation. However, new projects may also be bid, providing potentially more opportunities for Public Service to acquire projects at what is described as the best cost in this dynamic policy environment. Responses to the RFP are proposed to be due on October 6th, and given that very near deadline, the joint movements ask for a written decision on this motion by Monday, September 8th. The motion also asks that the Commission approve follow-on procedures associated with this proposed solicitation. Public Service would provide its analysis of the bids and proposed potential acquisitions in a report to be filed no later than December 5th. The procedures culminate in a written decision from the Commission to be issued in early February 2026, through which the Commission would approve projects. The motion further explains how this proposed solicitation process is not supposed to interfere with the just transition solicitation under review in proceeding 24A 442E and is scheduled for final deliberations this morning. I'm presenting this motion for the sole purpose of setting response time. The joint movements asked for a 7-day response time from when the motion was filed, or Friday, August 29th. This is intended to be aligned with that September 8th deadline for a decision from the Commission. The joint movements explain that this compressed time window is the result of the recent federal legislation, which requires, quote, quick and expedited work. I can give you a recommendation on the request for shortened response time.
That'd be great.
I suggest you set Friday, August 29th as the deadline for the party responses to the motion as requested by the joint movements through a brief ABC decision.
Commissioner Goodman,
I agree.
Commissioner Plant,
I agree.
as do I, and as you suggest, that can be an ABC order. So thank you, Mr. Davis.
Thank you.
But don't go anywhere. Let's keep going with 20. We'll come back to the just transition solicitation in a bit. Let's keep going with 25A-0220G, the Public Service Company 2025-2030 Gas Infrastructure Plan. Mr. Davis, Ms. Dundas.
Okay, well, on May 23rd, Public Service filed an application for approval of its second Gas Infrastructure Plan, or GIP. This GIP includes 62 planned projects that, according to the company, meet the Commission's GIP rule thresholds. The Commission set the matter for hearing and directed the company to confer with the parties on a proposed schedule. And on August 22nd, the company filed an unopposed joint motion to approve a procedural schedule, including discovery provisions. The parties also asked that the Commission vacate the pre-hearing conference that was scheduled for September 16th that was intended to determine a procedural schedule if consensus was not reached. The proposed schedule includes a deadline for the filing of supplemental direct testimony as directed by the company or by the Commission. It also includes a technical conference with the Commissioners on October 10th, which is prior to the answer testimony deadline of November 3rd. And the hearing concludes in January to be held January 16th through the 23rd, with sufficient time for the commission to render its decision to meet the 250-day decision deadline in late March. So unless you have questions, I can give you a recommendation on this procedural matter.
No, we'd welcome a recommendation.
I suggest you grant the unopposed motion, establish a procedural schedule in accordance with what the parties propose here, adopt the discovery protocols that the parties have agreed to, and include in the decision the standard procedures for the remote evidentiary hearing and for the filing and presentation of the electronic exhibits. Plus, I suggest that the commission extend the deadline for a final decision to that full 250 days pursuant to statute, and to clarify that further guidance on the technical conference will be by separate decision. And finally, the order should state that the commission will consider the scheduling of a public comment hearing at a future meeting.
Commissioner Gilman,
I agree.
Commissioner Plant,
I agree.
as do I. Thank you, Mr. Davis, and that can be in ABC order consistent with your recommendation. Appreciate it.
Thank you.
Proceeding number 24R-0306E. Rule modifications to protect tribal sites of historic and cultural significance. Mr. Gomez, 2 days before retirement, no rest for the weary.
Yeah, you would think there would be, but apparently not. Yes, so good morning, commissioners. Paul Gomez. I think this is the first time I've ever said this in a weekly meeting or in a hearing, but I'm your first assistant attorney general. I usually just say I represent the commission, but so I thought maybe one last time I'd throw it in there. But as background on this, on July 11th, 2024, the commission issued a notice of proposed rulemaking to amend the commission's rules regulating electric utilities at 4 CCR 723-3. Through the rulemaking, the commission wanted to establish rules clarifying the process by which regulated electric utilities and wholesale generation and transmission cooperative associations identify impacts to sites of historic and cultural significance to federally recognized tribes and present relevant information for consideration by the commission in the context of certain resource planning and infrastructure decisions. The amendments and proposed rule changes emerged from a highly sensitive backdrop involving the protection of the Sand Creek National Historic Massacre National Historic Site, following requests and advocacy by affected tribal nations during the transmission line and resource planning proceedings, but most notably by the Northern Cheyenne Tribe, in the context of Public Service Company of Colorado's resource planning process. The Northern Cheyenne Nation requested that the commission engage in rulemaking and other actions to facilitate the preservation of the Sand Creek Massacre National Historic Site from the impacts of energy development. Additionally, the commission recognized the vital government-to-government relationship between federally recognized tribes in the state of Colorado. Based in part on those considerations, the commission proposed requirements for electric utilities and wholesale cooperatives to coordinate with federally recognized tribes to identify and consider how best to mitigate impacts to significant sites and to present relevant information to the commission for consideration in the interests of robust participation from all the parties. The commission strongly encouraged electric utilities and wholesale cooperatives to engage early and thoughtfully with federally recognized tribes. The commission also viewed this rulemaking as an early step as it develops appropriate tribal consultation practices in pursuit of a well-rounded government-to-government relationships. In the NOPR, the commission referred to Senate Bill 21-272, which requires the commission to promulgate rules in which it considers how to best to provide equity, minimize impacts, and prioritize benefits to disproportionately impacted communities and address historical inequalities. The commission also noted that SB 21-272 directs that when making those rules, the commission is to identify disproportionately impacted communities, and in so doing shall consider minority, low-income, tribal, or indigenous populations in the state that experience disproportionate environmental harm and risks. The commission also referenced HB 23-1233, which created a statewide definition of disproportionately impacted communities that specifically includes communities on the land of the Ute Mountain Ute tribe and the Southern Ute tribe. The rules to be amended or added as part of the NOPR included rules 3301, 3102, 3605, 3613, 3616 through 3618, new rule 3620, and rule 3627. The NOPR decision C24-0494 was issued on July 11th, 2024, and when the commission provided notice of its proposed rules and referred the matter to an administrative law judge for further proceedings and disposition. On July 15th, 2025, ALJ Melody Birnbaba issued her recommended decision, number R25-0515. ALJ Birnbaba's recommended decision was a thoughtful and well-analyzed recommended decision encompassing 95 pages of background information, a recap of public comments, and a thorough analysis of her conclusions and recommendations. The ALJ recommended the commission not adopt the proposed rules and move forward with a rulemaking incorporating the comments received from the parties. The ALJ also offered a series of options for the commission to consider in moving forward with a rulemaking based on the comments received in the proceeding. I think it's important. There were quite a few comments raised by the parties with regard to the rules, but I think I'm in the interest of time, I'm just going to relate the comments related to the viewshed and significant site rulemakings, and that will give you a good idea of what the rest of the comments dealt with and the issues between the parties with those. A wide range of parties filed comments to the proposed rules, including the Southern Ute Tribe, the Ute Mountain Ute Tribe, the Northern Cheyenne Tribe, the National Parks Conservation Association, Western Resource Advocates, History Colorado, Colorado Solar Storage Association, and the Solar Energy Industries Association, GRID, the Kiowa County Board of Commissioners, Interwest Energy Alliance, Public Service Company of Colorado, Tri-State G&T, Black Hills, and the Colorado Independent Energy Association, as well as we did receive other comments from some state and federal agencies. So the ALJ noted in the recommended decision that despite the widespread recognition of the underlying intent, the proposed rules attracted broad objections from the utilities and developers. The objections spanned legal, procedural, definitional, practical, and economic areas, reflecting not only the intricacies of the Commission's regulatory environment, but also the challenges of integrating tribal consultation into state-level energy planning in a manner that's workable, fair, and non-contradictory to other mandatory obligations. Some of the major stakeholder concerns regarded statutory and legal limits on PUC authority. One of the key objections was that the proposed rules would require the PUC to undertake reviews and impose conditions that exceeded statutory authority, particularly regarding facility siting and land use decisions reserved for local governments, federal agencies, or recognized tribal nations. The parties pointed to 2920-104, which indicates that the Commission's authority does not extend to land use, facility siting, or permit decisions, which remain local prerogatives under that statute, unless specifically preempted by state or federal law. The repeated refrain in written comments and in the decision was that by treating site protection and consultation as a PUC enforced requirement, not simply as a reporting or coordination prompt, the amendments risk both statutory and constitutional challenge and could precipitate future litigation where tribal, local, and utility rights intersected. With regard to the definitions of significant sites and viewsheds and related concerns, from the utility perspective, they raised concerns that without clear definitions, project developers would be forced to either A, take an overly conservative approach requiring expensive, exhaustive site surveys and potential rerouting for every proposed site, or B, risk violating undefined rules and subjecting themselves to legal or administrative challenge. The Office of Archaeology and Historic Preservation recommended using established state and federal definitions of historical, archaeological, and traditional cultural properties as found in the National Historic Preservation Act, the Colorado Historic, Prehistoric, and Archaeological Resources Act, and the National and Colorado Registers of Historic Places. OAHP cautioned strongly against inventing new or catch-all definitions which would undermine existing expertise and well-accepted standards. And I think most importantly, from the tribal perspective, some tribal representatives requested greater authority to define significance, but recognized the need for technical vetting by qualified entities to ensure consistent application and protect sensitive information. The Ute Mountain Ute tribe, I think, presented some very interesting comments with regard to this and how significant sites would be identified. The Ute Mountain Ute tribe demonstrates through that the origin of indigenous knowledge. The tribe states that History Colorado's database does not include all sites significant to indigenous cultures, given at least in part that adding more sites to the database is a resource-intensive and difficult process. Tribal governments have the intellectual property of sacred and sometimes non-shareable indigenous knowledge. I think we heard part of that when the Northern Cheyenne made their presentation to the commission last year on their thoughts and on why the Sand Creek Massacre site was sacred to them, in which they did indicate that they revealed part of that knowledge that typically remains within the tribe, but nonetheless kept quite a bit of it to themselves. As a result, certain indigenous knowledge may only be available through a tribal government, such as its historic preservation department or office, and that the issue only becomes more complex. For example, traditional ecological knowledge is often held in trust by a tribal government's environmental department, whereas other kinds of indigenous knowledge may be reserved for inside the tribal government's elders council, as is the case with the Ute Mountain Ute tribe, and as we saw with the Northern Cheyenne. The Ute Mountain Ute tribe also highlights that the federal government has made clear that indigenous knowledge must be treated as expert knowledge and nothing less. It emphasizes that only the relevant tribal government can ultimately decide whether a site is significant to it. COSA and SIA submit that the definition of significant sites matters tremendously from an implementation perspective, and that the proposed definition is not clear. They explain that all cultural resources in History Colorado's database may qualify as a significant site, and not all significant sites may require the same level of protection to mitigate impacts. COSA-SIA assert that different types of significant sites may require different protection of a surrounding viewshed depending on their type, and that the proposed rules definition does not contemplate these differences or provide needed flexibility to treat different resources differently. I think a good example of the divergent interpretations is exemplified with the definition of what a viewshed is. The Ute Mountain Ute tribe emphasizes that viewsheds should be maintained in rules, explaining that a viewshed may be self-evident but may also vary depending on the cultural orientation of the viewer. It noted that viewsheds are places that influence or have been influenced by humans, and that landscapes where viewsheds are important may be associated with a person, event, historic activity, or cultural practice. Viewsheds may also implicate intangible elements such as works of art, texts, narratives, and regional identity expressions. As a result, it asserts that viewsheds are not specific to indigenous cultures. It explains that viewsheds that are important to indigenous cultures may not register in the same way to a Eurocentric mindset, such as a single butte that aligns with a solar solstice or equinox from a particular vantage point may have cultural or religious significance to an indigenous culture. It provides an example with viewsheds that sightlines are not the only sensory experiences that are culturally significant and worth preserving, explaining that soundscapes, locations of tactile importance, or olfactory stimuli also have importance that may not be readily apparent to a casual observer in the dominant culture. For example, at a location in the Ute Mountain Ute Tribal Park, hundreds of feet above the Mancos River, a visitor standing in a certain spot can hear the rush of water in volume similar to that experienced by someone standing in the middle of the stream. It takes the position that to the Eurocentric mind, the location may be an interesting combination of distance and local geography, while to a traditional mindset, the location may be imbued with cultural, ceremonial, or spiritual meaning. However it's viewed, the Ute Mountain Ute state that such a site demands preservation despite the fact that its uniqueness is unrelated to visual perception. The Ute Mountain Ute tribe also explains that tribal cultures always consider spiritual impacts to a significant site, and that in some tribal cultures, the sunrise and sunset orientation of a given site has important significance from a religious and astronomical perspective. And for all these reasons, the Ute Mountain Ute tribe argues, when possible, impacts to a significant site should be evaluated from a tribal perspective and not necessarily from on-the-ground physical impact perspective. The utilities and developers, on the other hand, take a different approach in addressing viewsheds. If the Commission adopts a rule defining viewshed, Interwest suggests that viewsheds be removed from the definition. If viewsheds remain, Interwest submits that the Commission must identify an objective and understandable methodology to define and quantify viewshed and viewshed impact, which must be discernible from the earliest development phase. Public Service asserts that although viewsheds should be considered when analyzing impacts to a cultural or historic resource, viewsheds are distinct from the underlying resource. Public Service elaborates that identifying a viewshed associated with a cultural or historic resource requires an individualized analysis that considers the nature and cultural significance of the resource. Public Service cites the example that siting energy infrastructure within the viewshed of the historic Brown Palace Hotel in Denver carries fundamentally different cultural impacts and considerations than siting energy infrastructure within the Sand Creek Massacre National Historic Sites viewshed. Public Service states that neither it nor the Commission are in a position to determine or identify in advance that a given site is eligible for listing, as that is a determination uniquely within these other entities' purview. As such, it suggests that the Commission work with tribal governments, History Colorado, and others to identify and map appropriate significant sites in the state through a rulemaking proceeding, which could ensure that information on significant sites is transparent and readily accessible to the public and stakeholders. Tri-State opposes including viewsheds in the definition as well, explaining that including viewsheds may result in an overly burdensome number of sites that would have to be assessed, and that as a practical matter, utilities typically lack site-specific route data at the time of a CPCN application. Tri-State agrees with Public Service that viewsheds relate to impact analysis and are not cultural or historic resources in and of themselves. Black Hills is concerned that the proposed rules lack clarity because the terms cultural resources, sacred objects, and viewshed are ambiguous. Without clarity on what those terms mean, utilities cannot identify impacts to them, propose mitigation, or describe requirements related to identifying and repatriating cultural and historic resources as contemplated by other proposed rules. The utilities also share a concern that proposed rules include sites registered in History Colorado's database, which is not accessible to the public. They are unclear whether utilities will have access to information necessary to comply with the proposed rules obligation to determine whether a geographic area constitutes a significant site under the proposed rules. The utilities are also in agreement that even though there is a process to request access to History Colorado's database, History Colorado gives no guarantees as to what information will be made available and when information will be provided. In support, Black Hills highlights History Colorado's policy that only qualified users have access to restricted information. Black Hills points to other notable History Colorado restrictions, including the type and extent of available data is determined on a case-by-case basis. Restricted sites location information will be provided only in rare cases, and the state archaeologist or other commensurate professional must conduct a manual review of each data request. It argues that these restrictions may limit or prevent utilities and ERP project bidders from identifying whether a potential site is registered or otherwise protected. The Ute Mountain Ute tribe emphasizes that the Commission's rules must address 5 essential and interrelated elements: tribal resources, cultural resources, historical resources, significant sites, and significant landscapes. The Ute Mountain Ute tribe indicates that these concepts are connected and represent aspects of the indigenous experience. The National Parks Conservation Association also weighed in and suggested the Commission approach to the definition of significant site as a framework, which may include cultural resource database that tribal governments maintain. It encourages the Commission to work in partnership with tribal governments to consider landscape level areas of cultural and historical importance as part of this definition, and to maintain significant site locations confidentiality in order to avoid looting. I think these examples provide an indication of the complexity of the issues surrounding the proposed rules to protect sacred or significant sites. It's clear what started as an effort at government-to-government cooperation and collaboration has detoured into an area well beyond the expertise or jurisdiction of the Commission. While well-meaning in its intent, the execution was clearly lacking in this rulemaking, and I certainly take a heavy load for that blame because I was one of the ones involved in this original rulemaking as well. It's evident that the rulemaking assumed a life of its own beyond what the commission had originally intended. It is for these reasons the ALJ recommended that the rules proposed here not be adopted and the rulemaking proceeding be dismissed. The ALJ did offer recommendations for options if the commission did choose to proceed with an alternative rulemaking. WRA filed exceptions to the recommended decision, and late yesterday afternoon we received a out-of-time response from the Ute Mountain Ute tribe to WRA's exceptions. WRA urges the commission to explicitly enter orders about each decision point it does adopt. Doing so is necessary to provide transparency and clarity to the tribes, utilities, and other interested parties, and is within the commission's authority, WRA argues. A failure to include explicit directives in the decision on exceptions would be a decision to throw away 2 years of concerted effort to address impacts to sites of historic and cultural significance and improve the processes for tribes to participate in commission proceedings. WRA goes on to state that a comprehensive approach to protecting sites of historic and cultural significance will require policies and regulations that apply both to the commission itself and to regulated utilities. In its decision on exceptions, WRA argues the commission should clearly lay out the future steps that it will take towards developing policies and regulations that govern regulated utilities. The Ute Mountain Ute tribe, in its out-of-time response to WRA's exceptions, states it wholly endorses WRA's statement that it is incumbent on the commission to act on the issues presented in this rulemaking if it is to faithfully execute its statutory duties to serve the public interest and promote equity in all of its work. Ute Mountain Ute recommends that the commission act expeditiously by clearly outlining any future courses of action following the recommended decision. Ute Mountain Ute agrees with WRA that this should include efforts to adopt a formal written tribal government consultation policy. As noted by the recommended decision, Ute Mountain Ute indicates it provided some examples of federal and state utility commission consultation policies for consideration. The tribe goes on to state that formalizing meaningful consultation could help improve the commission's communications with the tribes. Such a policy may also help further some of the commission's aims in the July 2024 notice of proposed rulemaking that were the original impetus for the rulemaking. The response notes the recommended decision specifically recommends that the commission engage with the Colorado Commission on Indian Affairs and meet with the state's 2 Colorado-based tribes, because this type of formal engagement may help advance the commission's effort to determine future rule proposals. These concrete engagement efforts can hopefully assist the commission in the adoption of formal tribal consultation practices, which can ensure meaningful consultation, interaction, and engagement with the tribal governments on topics significant to those entities, including protecting significant sites and cultural and historic resources. The ALJ also suggested, according to the Ute Mountain Ute, that the commission seek feedback from state and federal agencies that already have adopted consultation policies, including FERC and the states of California and Minnesota. The tribe also agrees with WRA that time is of the essence for the commission to continue its efforts on engaging with tribes, CCIA, utilities, and other interested stakeholders in ways that will ultimately result in codified commission rules that protect tribal significant sites. The commission should explicitly enter orders on the various decision points presented in both the recommended decision and WRA's exceptions. This course of action will help lay the foundation for the development of future commission policies on tribal consultation and engagement and regulations that govern regulated utilities treatment of tribal significant sites. I'd be happy to answer any questions at this point or move on to my recommendation.
Yeah, if you could give a recommendation, that'd be great.
Okay. First of all, I'd like to say that, point out that I think ALJ Merbav did an extraordinary job capturing the essence of the comments raised during the course of the rulemaking public comment hearings and the comments submitted in writing. The recommended decision was thorough and well-reasoned in its analysis, conclusions, and recommendations for going forward. I agree with WRA and the Ute Mountain Ute tribe in part that the commission should include explicit directions in its decision on exceptions as set out below. It is my recommendation that the commission adopt the conclusions of the recommended decision in its entirety and choose not to adopt the proposed rules. Rather, the commission should take this opportunity to alter its course here and consider promulgating a rule that adopts a policy of avoidance to express its commitment to protecting tribal sacred sites and cultural landscapes from unnecessary impacts during the planning and development of electric transmission and generation infrastructure. The policy of avoidance would inform commission review of certificates of public convenience and necessity for transmission or generation infrastructure, electric resource plans, clean energy plans, beneficial electrification plans, and other related projects and applications, with transmission coordination filings and utility best practices in project planning and community engagement. Without the requisite expertise needed to implement more prescriptive rules, adopting a policy of avoidance would encourage utilities and developers to work with tribal representatives and tribal leaders to identify areas of significance and sacred sites, as those areas are defined by the tribes themselves. To the extent utilities are able to reach out to History Colorado and engage its services, as well as the services of other experts, the commission would encourage them to do so in a policy of avoidance. While it does make some sense to adopt a new rule, either through the 272 rulemaking, which is already in progress, I would recommend that a separate rulemaking, beginning with workshops and possibly a miscellaneous proceeding and commissioner informational meetings, working with tribal representatives and leaders, utilities, and developers to create and adopt a policy of avoidance that is clear, usable, and that encourages discourse between the utilities, developers, and tribal nations. So that's my recommendation, to pursue that course and adopt the recommended decision in its entirety.
Commissioner Gilman.
Thank you for that thorough background, Mr. Gomez. Appreciate it. And congratulations on your retirement. I don't have any questions. I agree with your recommendation.
Okay.
Commissioner Plant.
Thank you, and thanks for your review. As Commissioner Gilman said, congratulations. We will miss you here and your guidance. I know that this isn't exactly the outcome that was hoped for when entered into this process, but appreciate all the time and commitment and effort put in by everybody, and I would agree with your recommendation.
I would also agree with your recommendation and say that can be an ABC decision consistent with it. And as chair and on behalf of the Colorado PUC, I just want to thank you for your 30 years of service, and say personally, it's been a pleasure working with you, and I'm going to really miss you. But with that, wishing you the absolute best in retirement, and would say it's well earned. So thank you, Mr. Gomez, for your service.
Thank you, commissioners, and thank you, Mr. Chair. And may I say that it has been a privilege and an honor working with each and every one of you. This has been an extraordinary set of commissioners to work with, and I have been very honored to work with all of you, given your dedication and commitment to the public interest. And so thank you. And with that, I will say, bid you all farewell and hasta luego.
Au revoir. Until we meet again, stay in touch, Mr. Gomez.
Yes.
Be well. All right. With that, Mr. Eden, Ms. McLaughlin, Mr. Mendelson, 24A-0442E.
Yes, good morning, commissioners. This morning, advisors are prepared to present the remaining items in Public Service Company of Colorado's Phase 1 Just Transition Solicitation, or JTS. Most of the issues today are items the Commission has previously begun discussing. Given the Commission's limited time, we'll try not to repeat the background and context that we've already provided in previous deliberations. We'll start off with a few loose ends regarding the company's load forecast, but I'll pause first for any initial comments or Commission direction.
Yeah, but before we jump into the details of the final issues, I just want to share some high-level thoughts about where we're at. Overall, I thought we have collectively taken many important steps in our deliberations to balance affordability, emission reduction, reliability, just transition, and other critical public policy goals. But first, based on the low load forecast that we adopted, and even with our proposed adjustments to electric vehicles and beneficial electrification projections, we're still approving the acquisition of well over 6,000 megawatts of new generation. In multiple ways, this will likely be the single largest resource acquisition in the history of Colorado and an over $15 billion commitment from customers. To put this commitment in perspective, total Xcel rate base in Colorado is currently roughly $12 billion. By any measure, this is an enormous resource acquisition. As modeled by Xcel in its low load forecast, this resource acquisition might include almost 4,000 megawatts of wind, 1,500 megawatts of solar, and 1,400 megawatts of peaking capacity. Although, of course, the final numbers will come from the phase two actual bids. And this is all on a current system with a coincident peak demand of roughly 7,000 megawatts. In addition to this, we're also approving a strategy put forward by the company involving multiple RFPs, an incremental resource need pool, and a strategic reserve fund to pre-order critical equipment. All told, these approvals likely commit over $250 or $300 million of additional funding beyond the core resource acquisition to provide flexibility and optionality if load growth turns out to be greater than expected. I understand that the company wants to acquire far more resources to meet new customer demands, even before those demands are contractually committed to Colorado. As multiple parties have argued, however, there is a real risk that if these new uncommitted loads don't materialize, it will likely substantially raise existing customer rates. Despite this concern, the company has stated that it is unwilling to share any of these risks, any material amount of this risk with existing customers, such that I believe we need to be cautious about acquiring new generation resources before the new load is contractually committed. Finally, given all these realities, I believe we're on track to approve a cutting-edge, precedent-setting resource acquisition, both in terms of the size and flexibility to quickly acquire additional resources, all while balancing affordability, long-term rate impact, emission reduction, just transition, reliability, and other core public policy goals. With that, I'm ready to resolve the final details, including the proposed mechanisms, contract mechanisms for the larger customers. But before we do that, I'll turn it over to you, Commissioner Gilman. Thoughts, comments, anywhere you'd like to go, including jumping into the details.
Yeah, thank you for that. And I agree with your opening comments. And I'll kind of just add a similar sentiment. We're sitting here today and have over the last several weeks and really the better part of a year been aiming to ensure that Colorado's largest utility is able to serve the needs of both existing and new customers to allow Colorado's cities, towns, and rural areas to continue to prosper and take advantage of the wonderful opportunities that come from businesses who want to move to or expand in Colorado. And certainly this is not a responsibility that any of us take lightly. And we've spent the better part of a year, as have many dedicated other state agencies and organizations, digging into the assumptions, the calculations, to get the forecasted load as zeroed in as possible. And we'll spend this morning kind of working on the last details of that. And certainly we've seen some concerns among towns and associations about public service company having available power to serve development for their needs. And I want those folks to know that we hear that. We've already also seen public comment from ratepayers asking to not have to shoulder an unfair burden of upcoming costs. And so we're here to really balance those. And I would say at a broad level, the ability of the company to timely interconnect new loads is, of course, in part a power generation issue. In some cases, it's an issue of the other infrastructure, which is largely being reviewed in other open proceedings. And it's also likely in part a customer service and process issue, which building more generation alone can't solve. And so our job here is to get the power generation forecast and plans the most reasonable and well-supported place possible. And I think it's important, as you mentioned, to put into context the combination of really the tremendous forecast for new large loads and to a lesser degree beneficial electrification loads has led to a forecast here that is multiple times, not just a little higher, the rates of growth we've seen in the past. And so all reasonable references are really kind of gone. And the best we can do is to look at the components of these forecasts to really determine what the best supported path here is. Certainly, we recognize there are real risks with building too little or too slowly. There are also very real risks with building too much too fast. And the evidence before us is that that could have very significant rate impacts for existing customers. So we're here balancing all of those risks, trying to look essentially at the evidence within this proceeding for what is really the best supported. And, I think as we'll discuss today, a lot of this comes down to issues of cost allocation and risk allocation to ensure that we are sending the message. We are certainly open to building the generation for customers who are willing to take the appropriate cost allocation and risk in that situation, and really look forward to discussing each of the details with you.
Yeah, I mean, I appreciate those comments, totally agree with them, and would say it even stronger. I think we're eager to support the execution of contracts that are fair and approve the generation needed to serve those contracts.
Yeah, and certainly agree with your points too. As we talk about the our expectations with regard to the forecast and what makes it in and doesn't, we're also really considering and have been supportive of thus far in our deliberations, really unprecedented flexibility in acquiring that generation and in moving to a much quicker, more nimble way to, as soon as we really understand and have assurance that that load is coming and has taken the proper cost allocation and risk, that we are ready, willing, and able to move with more nimble processes to ensure that that generation can be built as quickly as possible in order to serve the load that's coming.
Appreciate it, Commissioner Plant. Anywhere you'd like to go?
Well, I appreciate those comments by both of you. I agree with you wholeheartedly. I think that what the commission, with the help of the parties and the company, have come forward with here, and we're not completely done yet, but we're pretty close, is I think a really great balance. And a commitment that's being made from this commission is, if you make a commitment to Colorado, we make a commitment to providing the generation, and that is the regulatory certainty that I think this plan lays out. I think that initially what was proposed was that the ratepayers make a commitment to building generation prior to a commitment to develop here, and I think that was a little cart before the horse. And what we've done is established some regulatory certainty, so that a company that wants to make that commitment here in Colorado and wants to sign on the line, basically to say we're gonna do this, we've given the regulatory certainty to ensure that they're gonna have generation. And then the other thing that you mentioned was the flexibility and the approach that we're taking with the different phases, with the INP, with the SURF, with the CFFD, all these various different components of acronyms. Not only does that give us flexibility to make sure that we're providing sufficient resources for the commitments that are made in Colorado, but it also makes sure that we're getting the best price. We have noticed some changing federal policies over the last few years, in, out,
A few weeks.
yeah, tariffs, no tariffs, all sorts of things happening. And by breaking this up, we can make sure that we're actually, putting out the bids in the most recent, policy environment to be able to get the best possible price for the ratepayers and customers of public service. So I think this is a fantastic balance that represents both the needs of the commercial environment as well as protections for the ratepayers.
Just appreciate that, and would say all three of us been focused on this concept of balance and sort of reconciling these competing tensions. Mr. Eden, help us get through the last decision points.
Sure. So the first issue this morning is the size threshold at which large loads must agree to additional customer protections. As you'll recall, the Commission previously decided that large loads would need to sign an electric service agreement, or ESA, with the proposed commercial principles containing specific customer protections prior to being included in the load forecast. And I'll tee up the specifics of the commercial principles later, but the initial issue is the size at which this requirement kicks in. Public Service proposes that for purposes of the incremental need pool, only projects that are 100 megawatts or larger would be required to contractually commit to the commercial principles. WRA and SWEEP, however, argue that the commercial principles should be applied to all large load customers, not just those above 100 megawatts. UCA argues that this threshold should be reduced to 75 megawatts, but notes that the Ohio Commission recently approved a limit of 25. Conservation Coalition argues the limit should be 50 megawatts. And then earlier in your deliberations, you all discussed lowering the threshold to 10 megawatts to account for the likely size of oil and gas loads. So the issue before you right now is what size threshold should be used to define large loads. Above such a threshold, a large load would be required to contractually agree to the customer protections included in the commercial principles, including fair notice that they may be moved to a new large load tariff in the future. I'll pause for your discussion or can offer a recommendation.
Yeah, maybe I'll throw out some thoughts for discussion and see where you guys want to go. For me, regarding the size threshold, I'd set a peak 50 megawatt demand cutoff over the RAP horizon for customers, independent of whether they're interconnected to the transmission or distribution system, or whether they're classified as strategic economic development customers. This would be the peak demand across all meters billed to the same entity, very broadly defined. For these smaller than 50 megawatt customers that the company wants to add to the load forecast for the base and supplemental RFPs and to support the acquisition of new generation, I'd ask the company to have completed a facility study, begun relevant negotiations, and have executed either an ISA or an ESA or an equivalent contract if the load is distribution connected under an existing tariff. These customer ISA or ESA contracts would not be subject to the commercial principles or any fair notice provision or risk, and we generally leave the form and duration of the contract to the discretion of the company. As an example of how this might work, the low load forecast assumes 150 megawatts of new oil and gas demand. As the company signed new oil and gas customer contracts, both the base and supplemental RFP load forecasts and resource acquisition would be expanded for every new contracted megawatt above the 151 megawatts in the current PUC approved forecast. The same process would be used if the company wanted to include in the revised load forecast new data centers smaller than 50 megawatts. And just to emphasize what Commissioner Gilman already said, I just say that this commission is seeking to encourage the company to energize new loads under this proposed structure, And as you said, that will do what is needed to ensure that the appropriate generation and other infrastructure is timely available. So Commissioner Gilman, anywhere you'd like to go?
Yeah, thanks. Yeah, I'm okay with going with the 50 megawatts, which was Conservation Coalition's argued limit. I would say though, maybe the one caveat to some of what you discussed with regard to kind of what we're calling as the fair notice, that there will be a large load tariff coming up. I would say, I'm not prepared to prejudge what will happen in that tariff filing in terms of, I think it certainly could be reevaluated what the appropriate size threshold is for that tariff in that proceeding. So that's probably the only real modification I would offer there, is I think that is a more general notification to parties to large loads that this proceeding will happen and could trigger different tariffs, and certainly potentially those could be at different load thresholds.
So let's just, to make sure we're on the same page, if a 50 megawatt load signed a 15-year contract at an existing tariff, would you require that customer to be at the risk that the tariff would switch depending on the outcome of that case?
Yes, yeah. We're essentially saying like the company can't guarantee a rate to these large load customers at this point in time. We're about to litigate a tariff that is intended to set that rate. But you had maybe made some differentiation with regard to the size, that the folks above 50 megawatts would be subject to this fair notice. And I'm just saying, I think that's probably actually a feature that will be litigated within the tariff, what the minimum size criteria for the tariff is. And so it's probably not appropriate to set that now. But for the interim period, what are the expectations? The expectations are loads over 50 megawatts in the interim period, sign a agreement that includes the commercial principles, and are aware there's a potential tariff change coming. But I'm saying the potential tariff change is coming, and we have not actually set the size threshold for that at this time. I think that's just a fact.
So it sounds like you support everything I said, but would want to see a fair notice provision even in the below 50 megawatt.
That's correct. I think that actual feature will be set in the tariff proceeding. It is not set at this time, and I don't think it's appropriate to make any communication that it is.
I don't know that I'm there yet. Commissioner Plant, anywhere you'd like to go?
Yeah, if I understand what the distinction you're making, Commissioner Gilman, is that it's possible that in the large load tariff, there's a limit that's 25 megawatts, or we don't know what the limit is. And so if we establish, and even it could be 100, which would also, be in conflict with the number that we pick here. So, you would just put in a fair notice provision that we're not prejudging the large load tariff. It may apply to people below 50. It may be above 50. We don't know what that's going to end up being, but just everybody should be aware that there's that proceeding, and the fair notice is that it's possible that whatever large tariff is passed may apply to them in the future. And I would support that. I'd also support the 50 for the purposes of this and the outline that you laid out, Mr. Chairman.
Let me see if I can get on the same page with you, Commissioner Gilman. How about if we provided a safe harbor where below 20 megawatts, there was no fair notice provision, but between 20 and 50, there would be a fair notice requirement. Would that work for you?
Yeah, I guess. I mean, that's just for the interim period. Like, it would not. So even if we got to the tariff and picked a lower limit than that, any subsequent customers would still be involved in that. But you're talking about for the interim period?
Yes.
I think that works. Yeah, I don't know that it's entirely necessary, but I think it works. I mean, at the end of the day, this will be a litigated proceeding where people can represent their interests and argue for the position that makes the most sense. And that's kind of why I want to leave the determination up to there. Yeah, I mean, if that's a huge issue for you, I think that's fine. Again, we're really just talking about an interim period here that's perhaps a year long until the litigation of the tariff is done.
I just want to provide as much clarity to customers looking to come to Colorado about what their risks are and what their risks aren't. And while still
I will just point out that customers' tariffs can change. That is true for residential customers, commercial customers. It is a rare opportunity for a customer to be guaranteed a tariff for a long time. So
I'm not saying a rate, I'm saying a tariff class.
I mean, tariff classes can also change too, in terms of the criteria for normal customers. So I don't think we're looking at anything really extraordinary here. Like, this is kind of inherent to taking utility service. Your tariff class could change. But I'm okay with your modification.
All right, Commissioner Plant, you okay with that?
Yeah, I'm okay with that. I think it's worth noting that that over 20, I think, is sort of a distinction between the distribution system and the transmission system, and that makes a lot of sense. I'd also note, the oil and gas customers, which would largely be below this, they're obligated by state law to electrify. So, we're gonna take care of that if it comes one way or another. So, yeah, I think that makes a lot of sense. So I would say.
Yeah, and I think most of those guys are below 50 megawatts and some probably below 20 megawatts, although the record isn't clear. Mr. Eden.
All right. Thank you. Just to clarify, the 50 megawatt size threshold with the 20 megawatt safe harbor concept, that will be the determining factor for large loads, regardless of whether such loads are connected to the distribution system or transmission system. Is that right?
That's my proposal. It sounded like you both were okay with that, but let's clarify with the official vote. Commissioner Gilman.
Yeah, that's correct. And to the extent the language needs to be somewhat flexible, as I understood from the company, it's not called an ESA. If it's on the distribution system, they need to sign an agreement that commits to the commercial principles. But yeah, that's certainly the intent.
Commissioner Plant.
Yes.
Okay, great. Thank you. The commission previously voted to require large loads to have a 90% probability and specifically assigned ESA with commercial principles and the fair notice provision that CEC proposed. And again, this fair notice concept is that large loads would agree that they could be moved to a new large load tariff in the future. At the August 21st CDM, Chair Blank suggested the commission make the following changes to the large load contracts that the company seeks to include in the load forecast to acquire additional generation prior to the approval of the large load tariff. First, eliminate the ED and 90 and 100% language and structure, given the record evidence that data centers may still decide not to move forward even after signing contracts. Two, require the new large load customers sign both an interconnection agreement or IA and an ESA. Three, continue to require the long-term commitment in the commercial principles, but include the CEC fair notice provision that lets customers know that the tariff may change. Four, require that the credit support and exit fee provisions be included in the ESA as opposed to just the IA. Five, adopt UCA's request and increase the credit support and commitment to 6 months anticipated bills. Six, adopt UCA's approach and not allow large customers to be exempted from the ECA, PCCA, or TCA as part of the modified commercial principles. And seven, require the company to file in the upcoming large load tariff filing a detailed Colorado-specific IA and ESA that is consistent with the Commission's modified commercial principles and clearly lays out the credit support and exit fee provisions. So the decision point before you is whether to adopt Chair Blank's proposed modified commercial principles. And this includes the concept that only large load customers that sign both an IA and an ESA would be included in the load forecast, at least until the implementation of the large load tariff. I'll stop here unless you would like a recommendation.
No, I just would just emphasize one thing, like the situation with the less than 50 megawatt contracts. In the interim, before there's a final large load tariff, for customers that comply with these commercial principles, we'd expand the load forecast and the resource acquisition as new contracts are executed. With the incremental need pool and the other tools that we approved, we should be able to move quickly to build additional resources once these large loads commit to Colorado. Again, I'd very much like to see the company do what it can to support and encourage new load under this contract structure and commercial principles. So with that, Commissioner Gilman, anywhere you'd like to go?
Thanks. Yeah, probably just two things. First is with regard to, I think it was like the sixth item that you mentioned, Mr. Eden, what riders would be exempt or not. And again, we're just dealing with this interim time period, which is not expected to be that long. I think it's appropriate to just have them pay whatever riders they're subject to under whatever tariff they would be taking service. So presumably they would be taking service under a TG tariff. That already sets out what riders and adjustments and what conditions under which you take service. So I don't see any need to like reinvent the wheel with a new set of riders. I think it just confuses the matter, especially given that it's an interim thing. So I would just say whatever tariff they're going under in that interim period, they would be subject to those riders or exclusions. And then the only other
hold on. I'm good with that change. Does that work? Let you finish, and then I'll come back and see where Commissioner Plant is on the whole thing, and then we'll vote on your exceptions. I apologize.
I just have one other thing. I think this has been brought up, but I just want to make sure it's clear. The company has still advocated for negotiation abilities with regard to these, what we're calling commercial principles. I will point out, which kind of originated with an idea of the company. So these are not unreasonable things to ask, with that basis. But, the company still has a desire to be able to negotiate with these. And so to me, I don't think we want to get in the middle of every contract negotiation they're doing. But I think it's an important message that if the company chooses to negotiate out certain consumer risk protections and move forward, and if the deal goes south, the load doesn't show up, we don't end up getting the revenue to pay for what was built, I think there certainly is a possibility that the risk would be shared by the company at that point rather than other customers, since this is the direction that we're giving. So I think we've discussed that before, but just wanted to make sure that was clear.
Commissioner Plant?
Yes, I support that. And, I think all the changes that Commissioner Gilman proposed as well. And I think that, this really came up in the discussion primarily with Mr. Eiley in the hearing that, this characterization of 80%, 50%, 90%, these are all more style than substance. That you could have a variety of things that are different between, what they call 80%, but at 80%, you still haven't signed anything. And so, they're more triggers than they are percentages. And I think representing that appropriately makes a lot of sense.
Does that give you, thank you, Commissioner Plant. Does that give you what you need, Mr. Eden?
Yeah, I just want to confirm. I'm not sure I heard a vote from you, Chair Blank, on the.
I support Commissioner Gilman's comments, and okay. I believe Commissioner Plant does too.
Yes. All right. Thank you. Yeah, that gives me what I need on those points. And if I could, I'd like to just summarize the Commission's overarching decisions regarding large load and the underlying rationale as grounded in intervener arguments regarding cost, consumer protection, and emission reductions. Would that be okay?
Yeah, I'd almost view it as us asking you for a recommendation for inclusion in the order about the record basis for where the commission landed. So if you'd be willing to provide that, and if we could take a vote on that, that would be greatly appreciated.
Sure. So I think it's helpful to set the baseline with where we started. Under Public Services proposal, data centers that have started to negotiate either an ESA or IA would be included in the updated load forecast used for the base RFP. In addition, the confidential strategic economic development customers that the company first identified in rebuttal would be included in the load forecast, even if such customers haven't started negotiating an ESA or IA. Public Service argues its proposals are designed in part to protect existing customers given the conservative amount of data centers included in the load forecast and the commercial principles that will guide the company's negotiations with large loads. Several parties have raised concerns about this approach throughout this proceeding, however. For instance, UCA urges the Commission to ensure that non-large load customers are neither harmed nor forced to incur higher rates due to new large loads. UCA proposes a number of modifications to the company's commercial principles to reduce the risk to non-large load customers, some of which the Commission just adopted. In addition, WRA and SWEEP state that the record in this proceeding shows that the service requests from large loads are uniquely speculative, even though they account for the single largest driver of the company's unprecedented growth load forecast. WRA and SWEEP echo UCA's concerns about existing customers inappropriately bearing higher electricity rates because of the prospective new loads. They assert that under the company's current approach, residential rates could potentially increase by 50% by 2031. WRA and SWEEP also assert that the projected demand for large loads has the potential to significantly increase greenhouse gas emissions from public services systems at the exact same time that the company is seeking to decarbonize to meet state clean energy goals. Similarly, Conservation Coalition asserts the fundamental problem with the company's approach is that ratepayers would pay for new resources for new large loads before the new large loads contractually commit to any customer protections. Conservation Coalition notes that the company tries to downplay this risk by arguing that other large load customers will materialize if the current ones fail to commit. But at hearing, the company refused to commit to share with the financial risk of any associated stranded asset. Conservation Coalition asserts that if public service and its shareholders are not willing to bear any of the downside risk of the company's own proposal, ratepayers should not bear that risk either. Conservation Coalition specifically argues that the Commission should exclude large load customers until they sign long-term contracts implementing the commercial principles with customer protections. CEC takes a similar position as Conservation Coalition and WRA and SWEEP. This is particularly noteworthy given that CEC characterizes its members as some of public service's largest industrial customers and major economic engines in Colorado. In its statement of position, CEC argues that the unprecedented uncertainty and the new large load forecast requires protective measures to ensure existing customers are not harmed by new large loads. One such protective measure CEC advanced was the fair notice concept that the Commission recently adopted as part of the commercial principles. CEC acknowledges the company's concerns with the fair notice concept, but notes that it, quote, should not be an insurmountable hurdle for new large customers who are willing and able to pay the appropriate share of their cost of service, end quote. And then finally, I'd like to acknowledge that we've received several public comments recently that, among other things, urge the Commission to protect consumers from overbuilding and ensure that the cost of new generation and transmission meant to serve data centers are borne by those industries and are not shifted to residents and existing businesses. So advisors would recommend at this time that the Commission confirm that in deciding to substantially deviate from the company's initial proposal regarding large loads like data centers, the Commission found party arguments such as the ones I just referenced persuasive in finding a balance between flexible development opportunities, affordability, emissions reductions, and consumer protections.
That's certainly true for me. I've relied heavily on this statement of positions and other materials you referenced and support the recommendation. Commissioner Gilman?
Yeah, thanks, Mr. Eden, for laying that out. And I think you did a good job summarizing a lot of the major concern points of a lot of the parties, from difficulty in meeting emissions reductions targets to the certainty and real risk of potentially spreading these costs out to other ratepayers. And as was brought up in conservation coalitions arguments, they had stated the company failed to articulate any legitimate concern with the approach of requiring signed contracts before building the generation. And I think that's what you're hearing us really emphatically agree with. The company generally stated that large power users were unwilling to sign energy service agreements without assurance the company will build generation to serve them. What's the opposite of that? That we need to plan to serve them, build it all out, and only then do we get a commitment that they're actually coming. It's a non-starter. That's not a serious proposal. And I think we've really tried to work through the different angles of ensuring that we can provide that regulatory certainty that we would very much like to build to suit these loads, but need some assurance that they are committed to Colorado and will shoulder some of that risk so that we can actually build those resources. And, as UCA and others pointed out, not put undue risk on other ratepayers who are not taking this bet. They're not even involved in the conversation largely. And so we really need to ensure that we're making the most responsible decisions moving forward. And yeah, I appreciate you articulating each of those concerns moving forward. And also, as Conservation Coalition stated, at hearing, I had asked the company, who's really the only party talking with these large loads, the only party who even knows some of their identities or the potential locations they'll go, if they would be willing to shoulder the risk if we build it and they don't show up. And without hesitating, the company said no. So they are not willing to shoulder the risk. It's inappropriate to put all of the risk on other ratepayers. So I think we've really crafted a fair outcome here to ensure that that we protect other ratepayers, but are ready, willing, and able to respond quickly to real loads that are coming and have signed an agreement to join the system.
And I'd just add one more comment to Commissioner Gilman's point that I think you said Conservation Coalition put forward a number of a potential 50% rate impact to average residential rates by 2031. I think that didn't include the run-up in generation costs that we saw in the customer's rebuttal, in the company's rebuttal case. And I think it assumed fairly robust sales growth. So it could be higher if that doesn't materialize. So I think on this record, the risk is real. Commissioner Plant, anywhere you'd like to go?
Yeah, I agree. And, I would just to expand off of Commissioner Gilman's excellent comments on that. I think that, to boil it down, the companies are looking to they're looking to locate here are looking to public service to give them a commitment before they sign. Public service is looking to the customers to take the risk before a company signs. And all we're saying is it's up to the company. If the company signs, the generation will be there. And taking that risk off of the customers and just asking for a commitment before we commit to building that generation. And I think that's fair.
All right, Mr. Eden, keep us going.
Okay, thanks. With that, I'll turn it over to Mr. Mendelson for some issues regarding beneficial electrification.
Good morning, Commissioners. I'm Mike Mendelson of your advisory team. I'll be guiding you through the final two issues on the load forecast. First up is BE adoption levels. As you'll recall, the company incorporated aggressive implementation of air source and hot water heat pumps based on recent commission decisions in the company's clean heat plan and demand side management strategic issues proceedings. Most parties generally supported public services proposed adoption rates, although WRA offered slightly different trajectories. However, in its 813 deliberation, the Commission raised concerns that recent BE implementation rates appear far lower than the trajectories approved in the Commission orders referenced above, and that they assume BE implementation embedded in the company's load forecast goes well beyond the funding horizons and levels approved in the proceedings referenced above. The Commission agreed to require the company to reforecast BE adoption based on actual implementation rates, which could delay the CHP curves by as much as 2 years, but to further deliberate on how to finalize the forecast for the base and supplemental RFPs. I'll pause here for your discussion or can provide a recommendation for you to consider.
I'd welcome a recommendation.
All right. So advisors recommend the Commission require the following steps to the company's load forecast. 1, incorporate actual implementation rates through at least first half 2025, if not Q3 2025, in the updated load forecast for the base RFP. 2, delay remainder of projected BE adoption levels consistent with step 1 above, and continue until the funds currently approved via the DSM-SI and CHP proceedings are projected to be exhausted given current delays. 3, grow the final year BE budgets through the remainder of the RAP at the rate of inflation. 4, develop a thorough projection of likely BE adoption for both electric and gas systems and submit such as part of the company's upcoming 2026 DSM CHP proceeding. And 5, reconduct the load forecast for the supplemental RFP with step 4 projection if available at that time. If not available, conduct steps 1 and 2 with then current info in any load forecast that supports the supplemental RFP.
That makes sense to me, but curious to hear where you're coming from, Commissioner Gilman.
Yeah, Mr. Mendelson, no, I think that's reasonable. And obviously, I think it's helpful to point out at the onset that we're excited to support Colorado's leadership in decarbonization and electrification of loads. And what we're really trying to do is make sure this is as precise as possible. Certainly, if we way overdo it with regard to how much we're building for electrification, it could have the opposite impact of really raising rates and having a negative impact on how many people want to electrify. So this, like many other things, is kind of walking a fine line to ensure we have kind of the best available information upon which to base this. And I think your recommendations lay out a reasonable way to really take the outcomes of the prior proceeding, but adjust them just slightly for the delays that have occurred in that proceeding so that temporally we're getting it right, which feels appropriate.
Commissioner Plant?
Yeah, I support that approach. The only thing I'd add is that we also have changing economic situations and tax situations, and there's a lot of uncertainty in how that's going to impact our adoption rates and the market. So I think having this kind of flexibility makes a lot of sense.
Mr. Mendelson, keep going.
Alrighty. The next issue is tied to home electrification peak loads. In its forecast, the company incorporated a peak load of roughly 17 kilowatts or higher for all electric households, largely based on a substantial 7 kilowatt load caused by supplemental electric resistance heating, either built directly into the heat pump or consumed by separate standalone units. WRA challenged those assumptions and suggested the Commission adopt an average value of 10 kilowatts per all-electric home, which incorporates roughly 3 kilowatts of supplemental heating. Notably, when asked to provide supporting work papers and other sources, the company referred WRA on this issue to testimony that was filed in the DSP proceeding by Mr. Pollock. In its 813 deliberations, the Commission agreed to adopt WRA's 10 kilowatt value for all electric households. At this juncture, advisors simply want to confirm that that was the Commission's intent and to also recommend that the Commission revisit this issue in the DSP proceeding and potentially make a determination of the appropriate value to be embedded in the load forecast developed to support the supplemental RFP. I'll pause there.
Commissioner Gilman, this makes sense to me.
Yeah, that makes sense. And I'll point out, sorry, DSP does have a bit more testimony on this, but also we've got other proceedings that will be in the interim time before the supplemental RFP, notably the Clean Heat Plan next summer. And so I would say the intent here is to use the most up-to-date information in the supplemental RFP about this assumption that could come from the DSP. It actually could come from another proceeding. And, you know, I certainly think WRA's put forth a better reasoned value to use here. But this is going to be where I hope we make a lot of progress over the next few years in really fine-tuning what this beneficial electrification load looks like, both in terms of buildings and EVs. Certainly there is the promise that this is good for the system and helps provide downward pressure by selling far more kilowatt hours throughout the year. But that is really contingent on the idea that we minimize the peak system impacts here. So it's essential that we continue to work through these proceedings, getting much better data. And, you know, ideally, we've now had thousands of rebates given in these programs that the company could use their AMI to track and get far more intelligence about what is actually occurring. And then pair that with significantly higher ambition to enroll these customers in demand response, demand flexibility programs, so that we really have better control over their loads so they're not contributing so much to the peak system load. And so I'm excited to see those two things transpire. I would say those are an essential part of our vision in adding more beneficial electrification load. The goal here is not just electrify everybody and set it and forget it and not care one bit how they use it. We have to be strategic in order for this to actually result in the system benefits that we assume and hope for. And I think it's important to keep articulating that, to really keep pushing on that as the goal, so that this really results in ratepayer benefits, not, you know, some ratepayer detriments by just having far more loads hit at the system peak. That's not the plan. That can't be the plan. And so I think, you know, I'm hopeful we can work over those other proceedings to really improve data acquisition, but also improve the ambition to better control these loads, so that they really serve the benefits of the system that I think, you know, a lot of people hope they will.
I strongly support Commissioner Gilman's comments, and we'll have one thing to add. But why don't we go to you, Commissioner Plant, for your vote and any comments you'd like to share?
Yeah, I would support the Commissioner Gilman's comments and the motion as well, and I'll just send it back to you.
Yeah, so I guess I'd like to, you know, sort of given the problem you outlined, and particularly, I mean, this is maybe more for EVs than BE, but given the amount of EV charging loads that's showing up on system peak demand, I'd like to ask the company at the time of the next rate case to file a revised EV peak charging rate, separate in addition to the time of use rate. I'm really struggling with the company's forecast of the impacts of EV loads on system peak, even in the low case, and would like to explore different rate approaches to address that. So I don't know, Commissioner Gilman, maybe that's more the stick than the carrot you've been pushing, but I really feel like with this company, we're pushing on a string in terms of getting them to manage these loads off peak. So any comments on that? And, we're not deciding that here. It'd just be a request to file something in the next rate case that we'd explore instead of trying to do it on supplemental direct. So any thoughts on that? And I know I'm hitting you cold.
Yeah, I mean, I'm trying to figure out for who and like for which types of customers, and do we really have disaggregation at the level that would allow them, they're not going to be on a separate tier for their car than the rest of their house, and things get a little complicated there. So I don't know if you're just talking about a certain type of customer. I mean, my vision more was to move into the TEP, the next TEP, with intentionality that an incredible amount of focus has to be put on the managed charging and like actually legitimately actively managing the charging. I think we have some work to do in really harmonizing the existing TEP programs to make sure that we're properly incentivizing and moving to an actually managed situation, so that we can serve all of the different needs that kind of this load flexibility is able to serve. So that was where I had kind of set my sights to ideally set the programmatic way. Like, clearly, look, you can do it through programs and incentives, or you can do it through rates. I'm just not clear enough, probably, to order what you're asking for on how we would disaggregate customers with other loads, like from the rest of their buildings. But I think as you are, very much have run out of patience for the like, well, let us add the load now and build for it, and we'll come up with those innovative programs later. We'll manage them later. That's not how this can go. And I think that's a lot of the frustration that people are hearing today is like, this is not a new tirade for me on demand response and demand flexibility and the need to intelligently add these loads. That has to be our default plan, not like we'll build it all way bigger now and figure that out later. And so I think we're all trying to figure out.
I mean, good luck in the tap. I think you're pushing on a string.
Yeah.
I think
Yeah.
that's been our experience over 2 taps now. All right. Well, we don't have to order the filing. I think, how about some language in this order saying that we'd like to I mean, I'm fine with your thought about trying to do it in the TEP, but how about some additional language saying this commission would like to explore different rate structures
I
to
think
help address.
exploring tariffs and programs that better advance active management of these loads and far more proactively harmonizing programs to make sure more customers are eligible, more customers know about that they're properly incentivized to get in these programs and really drive it where we need to drive it. Especially for like plug-in hybrid cars, there's not a single one of those that should be charging on the peak to any reasonable person. So like we've got to really get our arms around this much better in those coming processes to make sure we're doing this as strategically as possible.
I would just say this commission has multi-billion-dollar distribution, generation, and transmission investments in front of us, in significant part driven by EV loads showing up on system peak demand. And I'm not willing to keep going, hoping that we're going to solve this problem in a tap. It's just pushing on a string for me. So Commissioner Plant, anywhere you'd like to go.
Yeah, I mean, I agree with your comments. I think that there's a couple of things that are different, and that may, if we want to be optimistic, may point towards, something changing as opposed to previous taps. I mean, number one, we've set an assumption of 50% managed charging for the modeling in 2030. That's 3 times the assumption that Excel's been working off of. I mean, I think they are at 10% today and increasing by 2.5% a year. So we've changed that to, we're going to assume for the load forecast that you're going to get to 50% managed charging. And I would also expect that we'll see that reflected in the DSP modeling as well. That's sort of the new standard. The question is how they get there. I think, Mr. Chairman, you've identified a variety of different, ways, either through rates, through, programs, whatever it is. But we're also creating a whole new aggregator program through the DSP, and there are. I mean, as you pointed out, Mr. Chairman, you can point to the capacity of batteries in EVs that are already out there in people's garages, all operating off of apps. The companies themselves, or I know that there's other companies that serve as sort of aggregators for a variety of different vehicle manufacturers. I mean, they can become a participant in this. And with a new program, we have an avenue to be able to actually do that and say, we're going to create, an opportunity for aggregators with EVs, and and really kind of push forward another model and another mechanism. I mean, right now, really, it's the EVA program that's that's the managed charging program. That's it. So I think we have some more tools at our disposal, and we also have set a goalpost within the load forecast.
We'll include that in the order, and we'll try and resolve any differences on the TBC process. I think that gives you what you need, Mr. Mendelson. Can we move on?
I believe so. If I could just quickly summarize, though, would it be okay if we, or the commission has decided to say that it will use the array of tools in rate making and program design in upcoming proceedings in order to solve this problem and mitigate potential costs? Just kind of keep it general like that.
Yeah, I think it's the VPPs, it's the rates, and it's the TEP, and we're going to look at all of them to make this resource a benefit, to a flexible benefit to the grid that creates optionality, not imposes multi-billion-dollar costs on the system, which is what we're seeing in these cases. So, all right, let's keep going. Mr. Eden.
Thank you. During your deliberations last week, the Commission continued to refine a suite of Phase 2 portfolios and an approach for including the just transition modeling credits in the Phase 2 modeling. When we left off, Chair Blank had proposed keeping the just transition credits for any project located within coal transition communities, but eliminating the bonus credits that would only apply to projects that were estimated to create a certain amount of jobs and property taxes. Relatedly, Commissioner Gilman had proposed 3 Phase 2 portfolios that would be run without any just transition credits. At a high level, the Commission agreed to adopt the 14 portfolios that staff proposed in SIR rebuttal, with certain modifications, including a no utility-owned gas portfolio, a business as usual portfolio, and the 3 portfolios without just transition credits. In addition, the Commission continued to question the need for the linear emission constraint contained in several portfolios. Advisors have a recommendation for how to tie this all together, but I'll pause first for your discussion or any questions.
No, why don't you give your recommendation, come back with questions, comments, or a vote?
Sure. Consistent with Chair Blank's proposal, advisors recommend modifying the just transition credits to eliminate the bonus credits, but retain the base just transition credit available for all projects located within the target communities. This approach is directionally consistent with advocacy from parties like CEI, Interwest, WRA, and SWEEP, and Conservation Coalition, who argue the bonus credits as applied will inappropriately bias the model towards gas generation. Interveners also assert that bonus credits are subject to gaming because there's no penalty if a proposed project does not actually achieve the estimated tax or job benefits. In addition to eliminating the bonus credits and consistent with Commissioner Gilman's proposals, advisors also recommend modeling 3 Phase 2 portfolios without any just transition credits. Specifically, Portfolio 3, a least cost portfolio, Portfolio 13, which is a version of the preferred portfolio, and Portfolio 14, a version of the accelerated emissions portfolios. Modeling at least some portfolios without just transition credits is supported by parties such as staff, WRA and SWEEP, and Conservation Coalition. And regarding the linear constraint that certain portfolios have, advisors note that requiring a constant pace of emission reduction disregards potential future step changes, such as development of new technologies or increased interregional transmission and market participation. On the other hand, the linear reduction constraint does provide scenarios that promote additional interim emissions reductions by requiring the model to acquire more wind, solar, and storage resources. Thus, advisors recommend the Commission retain the linear reduction constraint for Portfolio 9, which is one of the accelerated emissions portfolios, but remove the linear constraint from Portfolio 5 and 6, which are company ownership portfolios. For clarity, the Commission should direct that for the portfolios without the linear constraint, the company will keep all other emission constraints, for example, the 2030 and the 2050 emission reduction requirements, but will remove intervening constraints, including the carbon caps set forth in Section 2.11 of the technical appendix.
So I support that recommendation and appreciate you, Commissioner Plant, raising the issues with these linear constraints at our last deliberation. I hadn't really focused on it, so thanks for that. Commissioner Goodman.
Yeah, thanks, Mr. Eden. I'm on board with the recommendation. I think it solves a number of problems, as you articulated, with elimination of the bonus credits, but as well as just testing the JT credits in total with some reasonable portfolios. One of the reasons I picked Portfolio 10 to kind of have as the new 14 without JT credits was because it appeared to me to include a lot of the aspects of the USA, which had broad party support. And so I thought is, a somewhat likely portfolio in that sense. So I did just want to bring up one thing. In the case that Portfolio 10 is the preferred portfolio, just in the chance, that would make 13 and 14 exactly the same. So I would just say in that case, it wouldn't make sense for us to have 13 and 14 be identical. So basically in the event that the preferred portfolio is number 10, they should use number 9 as the basis for Portfolio 14, which just gives us one more variety, just in the off chance that I nailed it beforehand and accidentally picked the preferred portfolio there. I don't want two identical ones as 13 and 14. So that's a just in case kind of thing, so that we all know what to do. But other than that, I'm on board with your recommendation, Mr. Eden.
Commissioner Plant.
Yeah, I'm on board as well, but let me just throw one little wrench in the works. And also support your change there, Commissioner Gilman. So here's the wrench I want to throw in just to get your perspectives on this. As I mentioned, having the 2050 zero goal, I think is in really all of the proposals, with the exception of maybe is it the least cost or business as usual and the no utility owned gas. I would be interested, since we're in taking out the linear within number 9 and making that a no 2050 goal. And that would give us, number 1, we're reaching, the higher emissions in 2033, but it would give us an indication of whether or not that 2050, because it uses today's technology, it uses today's solutions to try and maximize the cost effectiveness out, 20 years from now, 25 years from now. And I just really feel like things change over the decades. And today's, projections of prices for renewable resources, out in 2045 are just it's crazy to be using that kind of data in trying to do that. And since we're already achieving that 90% in 33, it's a pretty accelerated emissions reduction. I'm really curious between 9 and 10, which would be identical with the exception of the 2050 goal, to see whether or not that 2050 goal is sort of artificially pushing up costs because it's front loading a lot of generation that we don't necessarily need today, but in order to get us to a 2050 reduction. So I just throw that out there as something I think that would be more informative than having that as a linear.
You've convinced me to move away from linear, and I don't mind doing it completely. It's Commissioner Gilman, anywhere you'd like to go.
Okay, let me make sure I got it. So portfolio 9 would be as listed, but instead of having a linear, it would move to nonlinear, and you would remove the 2050 constraint.
Yeah,
No, add it.
basically, take it out. Take out the 0% by 2050. So the 9 and 10 would essentially be the same except for the 2050. 10 has the 2050 0%, and 9 would not have the 2050 0%. So that we could actually make an apples to apples.
Let me think. I didn't hate testing linear at least once. Because kind of like the JTF credits, like we don't know what it does exactly in there. And of course, I think we all know like timing does matter with regard to carbon emissions, preferable to remove more earlier. So to my understanding, that's kind of what that was attempting to do, rather than kind of allowing it to save all those savings until right when you hit the target. Will it actually do that or not? Like, I don't know, right? That's what we're not aware of. So I'm a little apprehensive because I think the timing does matter. I mean, another option would be, and I threw this out last time as we were trying to kind of massage these portfolios and make sure we have what we want represented. I mean, I do buy your interest in the idea that is the 100% doing something weird just because we're limited to current technologies. And I too, like you, hope and I'm excited to see a lot of new things come on the scene by 2050. That will be helpful. So one idea would be to add it as a 15 portfolio. There's no magic to 14. I mean, what did we do? 28 or something last time? And like, I'm not saying that went great. That caused a lot of delays, but I think there's been a lot of focus already on really paring this down and trying to streamline. I'm just a little nervous because I don't know what the removal of the linear does, and that would be our only one left with it. So I would say, what if we just do a 15 portfolio? I mean, there's no magic. We don't automatically break the system when we go to 15. We've just been trying to be kind of as conservative as possible with the numbers, but perhaps this just bumps to 15.
Just to maybe create a 1-1-1 vote. I'm probably would just leave it as it is. And maybe I overreact to whoever spoke last. But I'd like to retain the discipline to keep this at 14 portfolios. I just think it sends a bad signal on delay. So I'd probably just leave it as it is. But Commissioner Plant, curious to hear what you'd like to do. If you want the 15, I'm not going to scream and moan.
Yeah, well, I'm not opposed to doing 15. What I think would be valuable is to have, a case where you're testing what is the impact of linear, what's the impact of the 2050, and so that you can do an apples to apples on both of those. If we added another, kept the linear one and added another one, I would say it would be nonlinear and no 2050. Then we would be testing all of those. And then I guess the question, I mean, we could go to 15, or the other thing is we could get rid of one of the other linear tests. Those are, they're a little bit different in that they're 80 by 30 and the other one's 90 by 33. And then
I think we were already going to we were going to remove the linear determination on those. So you were only with one linear determination.
I like let's just do 15. That'll give Commissioner Plant exactly what he wants. I don't think this one issue is some huge burden on the company, and then we'll still retain the one linear. So I think that gets all three of us happy. It's a 3-0 vote.
Let me confirm something with Mr. Eden. Not to cause more problems. So if we remove
no more wrenches.
hour 30, it's time. So if we remove the 2050 constraint, I just want to be sure. I would assume the other parameters stay the same, like with regard to, for example, for gas plants after 2050, it's my understanding that the company then factors in costs associated with hydrogen rather than gas commodity. We've talked about depreciating the gas plants. There was some 22 years. So I just want, I think my assumption would be those things remain. It's just not making the model get to 0, but you would still say replace the fuel with hydrogen fuel in the pricing at 2050. I just want to make sure I would interpret right. Probably a question for Mr. Eden and then a little bit Commissioner Plant. Do any of those things change that I'm not foreseeing?
Yeah, my understanding from prior deliberations was that would be true for the hydrogen cost, but not necessarily the requirement to depreciate all gas plants. I forget what it was, within 22 or 23 years. But that would only be that requirement would only be lifted for portfolios without the 2050 requirement, which right now is only the business as usual portfolio.
So your understanding is it would switch to the higher price fuel after 2050, but would not necessarily trigger that quicker depreciation?
Right.
So Commissioner Plant, I guess I just want to understand your intentions on the treatment of the fossil resources so that there's no ambiguity here when we finish.
Yeah. No, I appreciate that clarification, and I would stick with I can't remember how many years we decided on for depreciation. Was it 22 or 23? I would stick with that same depreciation schedule for that new one because I want it to be the same. I just want to see how much we're sort of falsely increasing costs because we don't know what future technologies have. So that doesn't impact the depreciation. So I would leave that the same so that we can compare apples to apples through all three of those. I think one is without the JT credits, one is with the goal, and one is without the goal. But other than that, they'd be the same.
Mr. Eden, can we get rid of portfolio 8?
We can do anything you want.
I need another vote.
No, portfolio 8 is testing company ownership, and the emission constraint in portfolio 8 requires a 90% emissions reduction by 2033. So similar to the accelerated, it's very similar to the accelerated emissions reduction portfolio. But it's just kind of another flavor testing the company ownership requirement. And I'll remind you that in the last ERP, the portfolios testing company ownership really weren't that useful because the model economically selected for a greater than 50% company ownership anyway. So it's possible that the portfolios that are really analyzing this company ownership percentage might not be that useful when we get to phase two.
I don't feel strongly about any of this, Commissioner Plant. Thoughts? I think we're going to get you what you want. Thoughts on 8?
You know, I mean, look, I'm all for getting rid of extras. If we don't think it's going to tell us anything that we don't already know, I'm all for getting rid of it. But if, you know, if we go to 15 in order to just get all of the scenarios in there, I'm fine with that too. So it's up to you, Commissioner Gilman.
Yeah, whatever you want to do. I think we should move on. So tell us what you
Yeah,
want to
I
do
mean,
and we'll keep going.
like, I think based on where we're at with the statute, where we're at with the updated settlement agreement, we also have the accelerated emissions portfolios kind of also test this company ownership too. So that's at 50%. So we have probably an excess of portfolios that just assume this 50% company ownership. So yeah, I agree. 8's probably the most duplicative of basically the accelerated emission. The only difference is one goes to 86 by 30 and the other one would have gone to 80 by 30. But I think that replacing Commissioner Plant's run with number 8 is fine. Although I would really rather they be like with their similar portfolios. Now we've fudged up all the numbering. So
Mr. Eden will fix
maybe
that
we
for
can
us.
do that.
He'll fix that for us on.
Bothers my brain if they're not adjacent to the others that are similar. But I guess it would be.
Let me ask a question, and just honestly, I'm not sure. Does the 80 by 30 really tell us anything? I mean, that's their safe harbor requirement, right? I mean, I don't think we expect that they're going to, you know, get below that, right? So are we better off doing 90 by 33 than 80 by 30? I mean, I think that's kind of the bare minimum. They're not going to give up safe harbor.
Well, let's get rid of 8. Let's do the one Commissioner Plant wants. Let's take up anything else on TBC and let's keep going. We got a long afternoon, Mr. Eden.
Right.
Okay, I think that gives me what I need. We'll eliminate that portfolio 8 and replace it with a portfolio that Commissioner Plant proposed, including keeping the assumptions about the gas depreciation the same as they are for portfolio 9 and 10, and then as well as the rest of the advisor recommendation. So with that, I think I'll turn it over to my fellow advisor, Mr. Greenberg, to do some cleanup items on the resource adequacy study.
Mr. Greenberg.
Good morning, Commissioners. As Mr. Eden said, just a couple of quick cleanup items. During your deliberations last Monday, you voted 2-1 not to require modifications to the resource adequacy study in advance of the base or supplemental RFP, but you also voted 3-0 to require the company to submit an application proceeding to litigate the assumptions to be used in the resource adequacy study for its 2028 ERP, including the assumptions regarding OWM or organized wholesale market membership. The only remaining question is when the company would need to file this application. Would you like a recommendation?
Please.
Advisors propose that the application be filed no later than March 31st of 2027. That would get us a final decision around the end of that year, 2027. The results of the RA study would not be subject to additional litigation in phase 1 of that ERP. So this should provide the company plenty of time to conduct the RA study following the conclusion of the application proceeding and prior to phase 2 of the ERP that will be filed in 2028.
Makes sense to me. Commissioner Gilman.
I agree.
Commissioner Plant.
I agree.
Thank you. Distribution connected resource credit.
Right. On Monday, last Monday, the commission agreed to exclude the 1.9 billion Harvest Chambers Sandown Cherokee or HCSC project from the transmission modeling adder, directed the company to work with the small stakeholder group in reviewing the calculation of the Denver Metro modeling credit, and agreed that all stakeholders should have the opportunity to comment on any changes made to the modeling credit. The commission also discussed interest in a modeling credit for generating resources interconnected at the distribution level, but did not come to a conclusion as to the level of the credit or where it would apply. As a reminder, the company proposes that any resource connecting to a constrained distribution line would be eligible for a $69 per kilowatt year modeling credit. All distribution connected resources would be exempt from the transmission adder, and those located within or west of the Denver Metro constraint would also be eligible for the Denver Metro credit. So distribution connected resources interconnecting to constrained circuits within the Denver Metro constraint would be eligible for a modeling credit that is the sum of the Denver Metro credit and the constrained circuit credit. The decision point is whether you want to approve the amount and applicability of the credit for distribution connected resources as proposed by the company, specify an alternative credit structure, or direct the small stakeholder group to work with the independent transmission analyst and the company to study this issue and perhaps revise the credit. Would you like a recommendation?
Yes.
Advisors recommend that you ask the small stakeholder group, as supported by the ITA, to work with the company to ensure that the credit for distribution connected resources, both within and outside the Denver Metro constraint, are set at a reasonable level. The commission should provide the same opportunity for notice and comment on any revision to the credit level and applicability that the commission previously provided for the Denver Metro modeling credit.
Commissioner Plant, I know you had strong feelings, thoughts on this one.
Yeah, I mean, what I was trying to get at was, having an incentive for locating generation on the distribution system generally. I think what the company put forward is an additional, obviously they don't have the transmission adder regardless of where they are. They have the 69 if they're on a constrained, and then they have the 69 plus if they're in the Denver metro area and on a constrained. And that may be, the best, combination of incentives. I don't, I mean, we could send it to this group to sort of evaluate the numbers and make sure that there's an agreement. I don't know what the impact of doing that is. I could go with either the company's proposal or, bringing it to the stakeholders. I know that there was some disagreement about the values that were being attributed and whether they were right. But
Commissioner Gilman, at the risk of supporting whoever speaks last, again, I think I could support Commissioner Plant. I want to support Commissioner Plant, but
I mean, I think it's reasonable to move it to the stakeholder group. I think there's really additional analysis and input that could be useful there. I don't disagree with your premise that it might be useful, but it would be helpful to get some additional input to get it right.
I'm going to vote with Commissioner Plant and just go with the company's proposal. So I guess this stays a 2-1 decision, and we'll see what we want to do on the TBC order. So let's keep going.
All right, very good. I think I'll pass it back to Mr. Eden at this point.
All right, thank you. So this next issue is a cleanup item from the Commission's discussion on the conforming bid policy and changes the specific power purchase agreement or PPA terms. While discussing the appropriate energy and availability requirements in section 12.1A of the model PPAs, the Commission discussed a recommendation from Interwest witness Mr. Singer to look at the availability performance over 2 years before the performance matures into a default and reduce the availability and cure period year requirements to 85%. A question arose, however, about whether the availability requirements were the same for solar and wind. If you like, advisors have a recommendation on how to move forward.
Yeah, I guess when I was trying to put forward a recommendation, I had some confusion about whether I was referring to battery energy storage or wind and solar. So I guess my request on this for battery energy storage and for wind and solar, which is just to return to the 2021 ERP and just mirror what we did there. So I don't know if you feel differently, Commissioner Gilman. Thoughts?
No, I think that's appropriate and clears up some of my confusion as I understood these to be kind of technology specific values. So I think that's appropriate and I agree.
Well, I think I might have caused some of that confusion. So Commissioner Flan.
I agree as well.
All right, Mr. Eden.
Quick clarification on that, because there's the model PPA for wind and solar that was filed as part of the direct case, but then in the updated settlement agreement, the parties came to some agreed modifications to the wind and solar availability requirements. So for as far as the wind and solar, did you want to go back to the PPAs that were filed in direct, or that final PPA that was filed as part of the settlement agreement?
The final.
Okay. Okay, so with that clarification, I also have one other PPA related matter. During the last deliberations, Chair Blank requested that advisors and council look into the labor provisions in the PPAs. We confirmed that the model PPAs require independent power producers, or IPPs, to certify they are in compliance with Senate Bill 23-292 and the associated apprenticeship utilization law and prevailing wage law, or are otherwise covered by a project labor agreement. And if it's okay, I'll just cut to the chase here. Given the broader context of the conforming bid policy, advisors appreciate that this was raised for confirmation, but don't think any further updates are needed. We recommend the commissioners confirm that Senate Bill 23-292 compliance provisions will remain in the model PPAs.
Makes sense to me. You good with that, Commissioner Gilman?
Yes.
Commissioner Plant?
I agree.
Okay, so at the last deliberations, the commission expressed interest in creating a process through which bidders could provide anonymous feedback to the commission regarding their experiences negotiating with public service. Advisors and council have evaluated this concept and suggest the commission consider one of three pathways to implement it. First, the commission could direct the company to make a joint filing with the individual bidders. Second, the commission could establish a process through which bidders can provide feedback to trial staff, who would then provide the anonymous comments to the commission and parties. Or third, the commission could direct public service in consultation with staff and UCA to modify the independent evaluator, or IE's, scope of work so that the IE remains engaged during the PPA negotiation stage. The IE could solicit feedback from bidders and provide anonymous results to the commission and parties. And I'll pause here for your discussion, or I can offer a recommendation.
No, if you could provide a recommendation, that'd be great.
Advisors recommend the commission pursue option 3, in which the IE scope of work is modified to implement the increased transparency into IPP and company negotiations. This would avoid further taxing staff's resources and is more in line with the purpose of an IE. The commission could direct public service with conferral from staff, UCA, and perhaps CIEA to include this new task in the IE's scope of work. The commission will be able to review the details of the scope of work when public service files the motion to approve the IE, but at a high level, the IE could be tasked with creating a confidential channel through which bidders would have the option to anonymously report their experiences negotiating with the company. The IE could then compile these communications and file regular reports in the form of anonymous survey results that stakeholders and the commission could review.
Commissioner Gilman?
Yeah, I think this suits the broad needs, so thank you. I agree with your recommendation to use the IE. And to me, this isn't something that's incredibly time consuming. I don't actually see them like sitting over anyone's shoulder during the negotiations, right? But I think having a mechanism by which, you know, it could be as simple as a survey to these bidders to actually understand we're sitting here today trying to solve a lot of problems that we have very little insight into, especially with regard to delays in the process. And so I think just understanding how to pinpoint the actual cause of delays and issues, rather than, you know, just pursuing measures here would be really helpful for the next ERP. And I'll say, I don't think this is specific to failed bids, right? There might be successful bids where learning more about how the process went is really helpful to us in crafting these processes a little better. And certainly understand there may be some cost to really modestly increasing the IEs role here, but I expect we've already incurred costs because of these things and really lack the insight or ability to directly fix them and kind of add different contract provisions as non-negotiable and do other things that potentially cost money. And this would, I think, ideally really help us be able to pinpoint the actual pain points, the actual things that are taking so much time or causing bids to fail in a way that provides sufficient anonymity that we could actually get responses and get insights from these bidders without them fearing, you know, that public service knows exactly who said what, since I'm sure they probably want to bid again. So I think this is helpful and would look forward to just getting more information so we can continue to make this process work better for everyone.
Just one comment. I totally support what Commissioner Gilman said, and I'd probably also do it backward looking on the 2021 bids and see what we can learn from that. I think just establishing a more direct communication link between the bidders and the commission without necessarily having everything filtered through the company could be valuable. Commissioner Plant?
Yeah, I couldn't agree more to both of your comments and proposed addition. And you know, I think the anonymous nature of this is just so critical, so that we can get, you know, the real story of what's happening without, you know, people or companies fearing that they'll be you know, looked at worse because of participating and trying to make the process better. So support that.
And Commissioner Gilman, are you all right with doing it backward looking from the 2021 ERP?
Yeah, I am. And I think like it'll kind of be up to the IE, I think, to some degree to figure out how to provide this anonymity. That's why I was saying survey or something. You know, if we even understand the broad areas we need to pursue, I think things fall apart a little when you make bidders give such specific information that is clearly identifiable or go out of their way to report a situation. All of that kind of reduces the anonymity associated with it. So I'm like, can we just pursue kind of rather broad areas to pinpoint where we actually have problems and where we actually need to pursue solutions? But yeah, I'm totally fine with doing it backward looking, and ideally that speeds up the process of us getting information to make this work better.
Cool. Last two issues, and then I got one more thing for you guys before we adjourn. So, Mr. Eden.
Thank you. In its statement of position, CEC requests that public service be required to rerun its phase one modeling prior to the end of 2025 with updated assumptions regarding generic prices. CEC agrees with the concerns Chair Blank raised during the hearing regarding the outdated phase one modeling, given the company's testimony and rebuttal that the model generic prices are significantly below market prices. CEC specifically recommends that the company be required to rerun its load forecast, PVRR, long-term rate analysis, and capacity expansion models with inputs that reflect the best and most current information available for each of the revised conditions. Would you like a recommendation on this one?
Please.
Advisors recommend granting CEC's request and requiring public service to provide the updated phase one modeling by December 31st, 2025. As CEC notes, this could help inform both the phase two process in this proceeding and the large load tariff filing.
Commissioner Gilman,
I agree.
Commissioner Plant.
I agree.
All right, as do I.
Okay, with that, I'll turn it over to Mr. Mendelson for one final item.
Good to see you again, commissioners. The last issue of the JTS for now is the aggregate distributed energy resources, or ADERs. Public Service Model 900 megawatts of ADERs, also known as virtual power plants or VPPs, as 4-hour storage device with essentially unlimited flexibility. However, the company concluded that the ADER testing resulted in minimal differences in sizing of the portfolios or impact on achieving emission reduction goals. ACE argues that the company conflated the total cost of storage assets for the costs it pays through the RBC or other ADER programs. However, since Public Service is not proposing any specific action related to ADERs, ACE suggests the Commission need not take any action in its Phase 1 order on these issues. Instead, it should examine them closely in related proceedings. WRA agreed with ACE's criticism of the company's approach to modeling DERs. It argues in its SOP that the company should update the modeling of generic ADERs in its next Phase 1 electric resource plan as follows. First, update the cost assumptions to be informed by 1, the company's relevant programming, such as Renewable Battery Connect and virtual power plant tariff options, and 2, ADER bids received through any administered competitive solicitations. And second, expand generic resource modeling to reflect distributed energy resources beyond battery storage, including consideration of energy efficiency, demand management, and distributed generation. I can pause here or provide a recommendation.
I can get us a recommendation. That'd be great.
Alrighty. Advisors recommend adopting WRA's suggestion with a slightly revised second bullet. So instead of expanding generic resource modeling to reflect DERs beyond battery storage, it would say address in its phase one filings whether generic resource modeling should or should not reflect DERs beyond battery storage, including energy efficiency, demand management, and distributed generation.
Commissioner Gilman,
I agree.
Commissioner Plant.
I agree.
As do I. Does that give you what you need, Mr. Mendelson?
Yes, it does. Thanks very much.
All right, I got one more thing to hit you guys on, mainly post-deliberation, and now that nobody's listening and have left, although I think this one's really important. Now that we've completed our deliberations, I have some final thoughts based on the comments in the JTS case from large customers, economic development interests, and local governments that suggest significant potential problems with current energization, infrastructure build-out, and interconnect approaches, and that the PUC process has perhaps not fully heard their concerns. Given this, I'd like to explore creating a forum for an outreach process under highly confidential protection to large customers and other related interests to better understand their issues and concerns. It seems like there's a decent amount of confusion and unhappiness, and I'd like to provide these large customers with a direct line of communication to the PUC so that they can better understand our processes, including what we've decided in this case, and to hear their broader concerns in a way similar to the IPPs that is not necessarily filtered through the company. So this outreach process would not be part of our decision here, and I'm not sure right now the best approach, although it may be in an M docket with the goal of having our staff elicit some initial feedback well before the January 31, 2026 large load advice letter filing. Either way, the intent is to open a process or discussion outside this phase one order to better communicate with these customers and hear these concerns. So I'm not proposing a vote today. I would like to bring this back in the next couple weeks with a more considered and specific approach, but wanted to raise this both publicly and with you guys to see what you thought. I just think when I was reading these large load comments that came into the JTS, mainly after the record closed, it just raised some red flags for me, and this is one way of addressing that. So, Commissioner Gilman, thoughts, comments, anywhere you'd like to go?
No, I think that's reasonable, and there's, I would say probably not with large loads, really, because the large load issue is very new, like very,
Right.
very new. But about 2 years ago, we are having some issues with serving load in Metro Denver, and held some workshops to really try and figure out what was going on. And those appeared to be primarily distribution system issues in terms of, so kind of getting back to my much earlier comments, that not every problem here is a problem of generation availability, right? Sometimes connecting loads are face issues with the distribution system. And in some cases, some of the indications are that some of these failures to get customers energized are customer service and process related issues that really rest somewhere entirely different than just building more generation. And so I think we would certainly benefit, and I think the very large now conversation of people who recently got very interested in this would really benefit from better pinpointing what the actual issues are. What are we trying to solve? And I will say we have another very large proceeding going on just this afternoon related to distribution system. But I think it's really crucial for us to have information in a way, kind of like with the PPAs. Like, I don't want to be in the middle of anything really going on, but we got somewhat high level complaints or concerns, and it's hard to pinpoint how exactly we address or solve issues that we don't know a lot about, haven't heard about until long after they're done. Largely everything we're looking at today is in years to come. That's what we're really analyzing here. And injected in that conversation in a lot of comments were current problems or past problems. And so I think it would be very helpful to better identify what are the actual sources of the problems. If these are customer service and process related problems, that's a very different solution than building more generation. And so I think that would really help us to identify how we interpret some of those things in proceedings like this, but also do we need to really improve our tools, something we have talked about also, in terms of more focus on performance-based rather than just rate-based, right? These proceedings become about a whole lot of money, and that can become a bit distracting if we need to focus more on customer service issues and what incentives or penalties need to be there. Some of which exist, but some of which are likely very insufficient for where we are now. Then I think that would be super helpful information. So I support it.
Yeah, I think it's really well said that these problems maybe, we talked about this a little in the outage customer service presentation by trial staff, where the company had cut O&M budgets by a ton and had grown capital spending by a ton. And, it just seemed to create problems that weren't amenable to solution by, like you say, more generation, more transmission. So really appreciate your comments. Commissioner Plant, anywhere you'd like to go?
Oh, I don't have much to add. I think that it's a great proposal, and we'll kind of figure out what the right way of doing it is. But I think that the advantage to us is to really understand these individual issues, which I think a lot of times, as you pointed out, maybe are being caused by a variety of different issues that are, external to, active proceedings, but because there's an interest in trying to influence an active proceeding, it sort of gets lumped into that. Um, from the company's perspectives, the PUC process is a sort of an esoteric and a little bit dense process. It can be a lot to try and understand, what are the consequences of various decisions we're making? What are we saying? What are we not saying? And what opportunities are still available to them? And what commitments have we made here at the commission? And we try and be as clear with that, and I think we spoke to that as it relates to the JTS pretty extensively this morning. But a lot of times, that doesn't filter down to the individual company. So having some sort of avenue for them to be able to interact with us and really get a better understanding of what their options are, and what we can do on our side is good for the companies as well.
Yeah, I like that thought that it's not just us hearing from them. There may be value from them hearing from us. All right. I think it'll take 2 or 3 weeks before I can bring this back, but I'll work with the council advisors and the director's office to see if we can't frame up a discussion sometime in September with the goal of getting meaningful feedback well before the January 26th advice letter filing. With that, just want to thank everybody, advisors, council, both of you, the parties, the company, for the conversation and the discussion over the prior months. It's an incredible lift with an enormous resource commitment on the back end. So with that, see you in an hour and a half.